Hi, my name is Conor Johnstone. I'm a specialist motion defence solicitor with M.A.J Law. I wanted to really quickly just talk about THC because as a firm that specialises in drink and drug driving, one of the most common types of drug driving cases that we defend are drug driving cases involving cannabis, involving THC. To give you an idea as to how low the current legal limit is for THC, it's around 400,000 times lower than the equivalent legal limit in place for alcohol in blood. 400,000 times lower. So it's an extremely low legal limit. And what that means, of course, is that if you've consumed cannabis, usually within the last 24 hours, or if you're a regular user of cannabis, that you're more than likely going to fail the test. But that presents problems, and there's always a couple of things that you want to check with THC analysis, and generally the kind of unfairness that can be created when the police labs and the government labs interpret data in order to form results. And these are the results that are given back to the police of your sample that's being tested, how that data is interpreted and how those results are generated. Certainly I know when I first started challenging drug driving cases, I just assumed, and perhaps you'd agree with me, I assumed that when they test a sample of blood for THC, they'll test it once, they'll generate a result. If you're over, you're charged. If you're under, you're not. It's a little bit more complicated than that, because they may test that sample 4 times, 5 times, they may test it more than that. Now, the unfairness is created because rather than picking the lowest result, as they might do with alcohol in breath, for example, when you blow into a breath machine, you'll generate 2 readings and they always pick the lowest one in the interest of fairness. With THC, they won't do that. So that independent lab won't pick the lowest reading that you have produced or that has been generated from the testing or the analysis of your blood sample. They'll calculate a mean average, and you can very quickly see how that can be unfair. For example, if you produce, let's say, 3 readings, just by way of an example, one of those readings is 2, one of those readings is 3, and one of those readings are 4, on a mean average, you're 3, so you're over the legal limit. But actually the lowest result wasn't over, it was 2, so it was on the legal limit. So you're still charged with drug driving in theory because you are over the legal limit, but that's based on an average. So the argument from our point of view, very clearly, is that the court can't be satisfied beyond doubt that you are guilty of an offence if one or more results generated by an independent, apparently accredited lab has placed you on or below the legal limit. Also, the use of decimal places. So when they report a result for alcohol in blood, they don't use decimals. They just report that figure as a whole number. 89, 140, 360, it's a whole figure. But when they report a result for cannabis or any other drug below 10 micrograms, they report it as a decimal place. And that too can create a little bit of unfairness, because if your result is 2 micrograms, stick a decimal place on, you're 2.5, you're over the legal limit. And that too can be a problem. Decimal places they're tiny, tiny quantities of drugs, and that's just placing you over the legal limit. And we certainly work with an expert that we've worked with for a very long time who believes that decimal places shouldn't be used in this area of forensic science, and that there's very clear guidance that figures should be reported as whole numbers, and if a decimal place is generated, it's good practice to round down to the nearest whole figure. So if it's 2.7, 2.8, they round it down to 2. What I'd also want to check are blank solvents, and this point may well be applicable if you're significantly over the legal limit for THC. So when a lab tests a sample of blood for THC, they won't just test that sample on its own. It's usually amongst a batch of other samples, say 20 or 30 samples. And I think the reason why labs will do that is because it's an expensive, time-consuming process. Now, these labs are run for profit, they're there to make money, and they have to make sure that they try and streamline that process. It has to be efficient, and so they'll test those samples in a batch of, say, 20, rather than just one sample on its own. Now, what quality control standards require is that a blank solvent is injected between the test of each person's sample. and that may not happen. So if somebody with a blood sample is tested before yours, and that blood sample contains a very high concentration of THC, that particular lab fails to inject a blank solvent between those two tests, you have what's known as carryover. And that's where a certain amount of THC from the previous person's sample is carried over into yours. Now, in order to prevent that from happening, that lab should inject a blank solvent. And that blank solvent clears the instrument and it makes sure that the previous sample doesn't influence the one after. But because drug driving is brand new, that's not yet a requirement. That's not a requirement issued by the forensic science regulator. And so some labs that we found recently haven't been injecting blank solvents, and that can therefore increase the level of THC or any drug that's the result that the lab have generated. Clearly a problem, unfairly putting you at risk of a prosecution when you otherwise wouldn't have been. So what I would also want you to do is take a look at my video which discusses the streamlined forensic reporting protocol, the SFR1, and how we can try and win cases by the way the prosecution introduce forensic evidence in these types of cases. Of course, if you also want to have a chat with me or any of my colleagues here, please give me a call on the details on our website. Thank you.